So I won't need to tell most of you that in the Back to the Future movies, the car that Marty McFly uses to travel back and forward in time is a DeLorean. A DeLorean is an actual car made by DeLorean Motor Company, which was started by John Z. DeLorean in 1975. It's got a unique look. The most snazzy feature is probably the so-called gull-wing doors that make it look all futuristic, and it's got stainless steel outer panels, and it isn't shaped quite like any other car you've probably seen. In the Back to the Future movies, of course, they used a modified version of the DeLorean. It had thrusters on the back, which of course a real car doesn't have, and it had weird wiring and tubes and a flux capacitor inside, which of course doesn't exist. While the real DeLorean cars looked interesting, they didn't sell quite as well, unfortunately, as Mr. DeLorean hoped, and DeLorean Motor Company went bankrupt in 1982. In 1989, John DeLorean and Universal Pictures signed a license agreement in which Mr. DeLorean agreed to allow Universal to use the name and appearance of the DeLorean car for merchandise and commercial tie-ins relating to the Back to the Future movies, in exchange for 5% of Universal's net receipts from merchandise and commercial tie-ins that use the image of the DeLorean car. A commercial tie-in, by the way, means that a third party, that is, someone who's not involved in the making of the film, uses images or the logo from the film to market their products, like Burger King putting the Back to the Future movie logo on its drinking cups, for example. In 1995, mechanic and DeLorean enthusiast Stephen Wynne formed a new entity called DeLorean Motor Company, which acquired the inventory and the intellectual property associated with the old DeLorean Company, including the trademarks. John Z. DeLorean had nothing to do with the new DeLorean Motor Company. Universal, which is now called NBC Universal, continues to this day to sell Back to the Future merchandise, which of course features the iconic DeLorean. In December 2023, the new DeLorean Motor Company sued NBC Universal, claiming that NBC Universal breached the license agreement it signed with John DeLorean back in 1989 by not paying DeLorean Motor Company the royalties it was allegedly entitled to under that agreement, and also for infringing the trademarks associated with the DeLorean name and the iconic image of the car. NBC Universal actually did pay DeLorean Motor Company royalties over the years on its merchandising relating to Back to the Future. But the new DeLorean Motor Company claimed that NBC Universal wasn't paying all of the royalties that DeLorean was allegedly entitled to. NBC Universal filed a motion for summary judgment, meaning basically that it asked the court to rule that there's not enough evidence to support the claims against NBC Universal and to dismiss the case. The judge ruled in NBC Universal's favor on the issue of whether NBC Universal breached the 1989 license agreement. This was because the agreement was between Universal and John Z. DeLorean, not between Universal and the new DeLorean Motor Company. Also, Mr. DeLorean, who again had nothing to do with the new DeLorean Motor Company that again was started by Stephen Wynne, didn't assign his rights under the 1989 license agreement to the new DeLorean Motor Company. However, the judge denied NBC Universal's motion when it came to the trademark infringement issue. The new DeLorean Motor Company did, as I mentioned, buy the intellectual property associated with the old DeLorean Motor Company, including its trademarks in the DeLorean name and the image of the car. So there wasn't any dispute that the new DeLorean Motor Company owned the rights it needed to own to claim trademark infringement. Also, as I've talked about on this channel, to prove trademark infringement, the plaintiff, that is the person who's suing, has to provide evidence of what's called likelihood of confusion. That is, that the use of the trademark on the goods or services being sold by the defendant would suggest to the average consumer that those goods or services were being sold or endorsed by the plaintiff in some way. NBC Universal argued that there wasn't any evidence that people were confusing the customized Back to the Future DeLorean with its flux capacitor and all those fictitious add-ons with the real-life DeLorean. And DeLorean Motor Company, of course, only had a trademark in the image of the real-life DeLorean, not the one with the flux capacitor. When someone buys Back to the Future merchandise, like, say, a t-shirt with the movie logo and the futuristic DeLorean on it, they don't think that the real DeLorean Motor Company has anything to do with the movie, or at least so the argument goes. But DeLorean Motor Company offered evidence showing that, in fact, a lot of people have come to them and tried to buy a DeLorean car in the style of the Back to the Future one, with the thrusters and weird external lighting and so on. Why somebody would do that, I don't know, but I guess there's no accounting for taste. In any event, that evidence suggested that some people did, in fact, believe that DeLorean Motor Company was selling or had somehow endorsed or approved the futuristic custom DeLorean from the Back to the Future movies. In other words, there was evidence of consumer confusion. Anyway, the judge thought this and other evidence that DeLorean Motor Company submitted was sufficient to justify denying NBC Universal's motion as to the trademark infringement claim. In other words, he ruled that a jury could find, based on the evidence of consumer confusion, that NBC Universal had in fact infringed DeLorean Motor Company's trademarks. What does this case teach us from the point of view of independent film? This case illustrates why it's important to have a clear chain of title. When the legal paperwork relating to your film makes clear who owns the intellectual property rights associated with the film, usually meaning the copyrights and the script for the film, and who is licensed to do what with those rights, that's referred to as a clear chain of title. The chain of title becomes unclear when the legal documents don't make clear who owns what and who's licensed to do what, essentially. For example, some indie filmmakers form a limited liability company to serve as the production company for their films. Generally speaking, that's a good idea. But what they neglect to do is make sure that there's a contract that assigns the necessary rights to make the film to the production company. Suppose that you sign an agreement with a screenwriter allowing you individually to make a movie based on the writer's script. Then you form a production company to make the film, and it raises the money you need and writes the checks and signs the contracts that are necessary to get the film made. But later, when a distributor approaches you because you made such a great movie and they want to do a distribution deal, the distributor notices a problem. The production company was never actually authorized in writing to make or distribute the film, so it can't assign the distributor the rights that it needs to distribute the film. Now, this problem is easy to deal with if you're the sole owner of the production company. You just sign an agreement with the production company that assigns the filmmaking rights, the rights to make a film based on the script, to the production company. You can actually sign for both yourself and for the company in this situation. But suppose that the screenwriter signed an agreement with someone else, say your producing partner, and now, after the film has been made, you're no longer getting along with your producing partner. The usual unfortunate creative differences. Now you have to try to get your partner to sign an agreement assigning the right to make the film to the production company, which they might not want to do, or you might have to pay them a bunch of money that you hadn't originally put into the budget to get them to do that. This is one reason why it's a good idea to form a production company as early as possible in the filmmaking process, and make sure that at about the time you form the company, to draw up, or have your lawyer draw up, ideally, a contract that assigns the right to make the film to the production company. This Back to the Future case, of course, results from much bigger and possibly more expensive confusion over who owns the merchandising rights associated with the DeLorean car. Because the chain of title regarding those merchandising rights was unclear, and to be fair, involved documents and discussions that went back 35 years, attorneys had to be brought in to fight over who owned the rights, and everybody paid a lot of legal fees as a result. So I hope that this was helpful to you in understanding this Back to the Future merchandising rights dispute, and also its implications for independent film, and thank you for watching.